viewers, my name is Patience Twinomugisha. I'm a Senior Legal Officer at Judicial Service Commission. Many times, death is sudden and unexpected. And the unexpected nature of death can lead to significant grief and challenges for survivors. Today we are going to discuss what happens when a person dies without leaving a will in place. If you have not subscribed to our YouTube channel, please subscribe to our YouTube channel so that you do not miss out on this and many other teachings on law and administration of justice. In our previous series, we handled what amounts to a will. How can you write a will? Where can you keep your will? We also went on to handle what happens if a person has died but they have left a will in place. What process takes place? Today, we are going to look at the uncertain situation that a person has passed on and not left a will in place. When a person dies without leaving a will in place, their property or their estate is managed by an administrator whom court grants letters of administration to manage the estate. You may ask, what are letters of administration? Letters of administration are a document that has been issued by court that grants powers to a person to manage and distribute the estate of a deceased person. What happens next? The person has passed on. The family will nominate a representative who can help the family process a death certificate. The death certificate is acquired from NIRA. You go to the nearest NIRA office in the district where the death has occurred and you apply for the death certificate. NIRA will require you to have a death notification record, which you can get from the medical facility where a person has passed on, or you can get it from the district at the sub-county or at the office of the town clerk. Once you've gotten the death notification record, you will need your national ID, a copy of your national ID. You who is applying for the death certificate, a copy of the national ID of the deceased. You will need a medical proof of medical cause of death or a post-mortem report. There is a fee you pay, and then after, you'll be granted the death certificate. Once you have this death certificate, where do you go next? You will report the death to the Office of the Administrator General. The Office of the Administrator General is the office that is mandated to manage estates of people who have died without leaving a will behind. Or if you've left a will behind, disputes have arisen in the management and distribution of the estate of the deceased person. Once you reach the Office of the Administrator General, a file shall be opened up in the names of the deceased person. There are certain documents the Office of the Administrator General will require you to have in place. For example, the death certificate, if there was a surviving spouse, certificate of marriage, list of all the beneficiaries of the deceased person and their identifications. If a will was left behind, they will ask for a will to be brought in, a letter of introduction from the LC of the area where the deceased person passed on from. Once you submit these documents to the Office of the Administrator General, they will organize a family meeting. the Office of the Administrator General may hold this meeting or delegate the powers of holding the meeting to the Chief Administrative Officer at the district. Once this meeting is held, they will require the family at that meeting to choose a person or persons who can be granted a certificate of no objection. Once one or two people are nominated, it could be the spouse, the surviving spouse. It could be a spouse and a child. It could be a brother, a sister, a parent. Any person can be nominated to be eligible to apply for a grant of letters of administration. Once this person has been nominated, they will be issued with a certificate of no objection from the Office of the Administrator General. With a certificate of no objection, then the person will be ready to apply to court for a grant of letters of administration. You may ask, to which court can I apply for the grant of the letters of administration? If the value of the property of the deceased person is valued above 50 million shillings, then the application is taken to the High Court. If the value of the property is below 50 million shillings, all the properties put together, if their value is less than 50 million shillings, then the application is taken to the Chief Magistrate's Court. The application for the grant of letters of administration is then published in a popular newspaper. In our case, it can be the New Vision or the Monitor. If you look at the back of those newspapers, you will find that there are a number of publications of people who are applying for grant of letters of administration. After 14 days from the date of publication for the grant of the letters of administration in a popular newspaper, proof of the publication is returned to court. Once that is done, court will call for identification of the applicant and the beneficiaries of the estate of the deceased. Once the identification has been done and there is no objection to the application for the grant of letters of administration to the applicant, court will go ahead and issue the letters of administration. These letters of administration, many people ask, can I inherit letters of administration? If my father was an administrator of the estate of his brother, if my father passes on, can I take over the letters of administration and do the work? No. Letters of administration cannot be inherited. Letters of administration are a document that empower the person who has been granted the letters to manage and distribute the estate of a deceased person. And these letters of administration expire after 2 years. Once you have been granted letters of administration, the next step is distributing the estate. You collect all the property of the deceased, pay out the debts, take care of funeral expenses, take care of the immediate needs of the dependents of the deceased person, collect out all income and all that was owed to the deceased, and then distribute the estate according to the percentages that are provided under the law. Once the distribution has been done, within a period of 6 months, an administrator is required by court to file an account into court, informing court of the progress of distribution. This is what we call an inventory that is filed within 6 months from the date of issue of the letters of administration. You may ask yourself, how is this property distributed? What are the percentages that are provided by law? What of the family home? Can it be distributed? Please join us next time in our series where we shall be talking about the percentages of distribution of an estate that are provided under the law. Thank you for joining us in this episode. Please, if you have not yet subscribed to the Judicial Service Commission YouTube channel, please subscribe, like the video, and even share with your friends and loved ones. See you next time.